Respondent in the appeal, AIG Europe Limited and Woodman and others.
Lord Mance will explain the decision of the court.
Under the Solicitors Act 1974, the Law Society may make rules requiring solicitors to maintain professional indemnity insurance. The Law Society has made rules requiring them to have insurance satisfying certain minimum terms and conditions. These include a minimum figure for which solicitors must be insured for any one claim. They also permit the aggregation of claims in various cases, including where the claims arise from, quote, similar acts or omissions in a series of related matters or transactions. The present appeal is about how far aggregation is permitted in the following circumstances. Development companies in the Midas International Property Development PLC group aimed to develop 2 holiday resorts at Peninsula Village in Turkey and in Marrakesh, Morocco. The finance was to come from private investors who were to have security over the development land. Separate trusts were set up to own or hold a charge over the 2 development properties. The developers' solicitors were the initial trustees, and the investors were the beneficiaries of the trusts. The solicitors were to hold the investors' advances in 2 escrow accounts, not to be released to the developers unless and until the assets held by the particular trust covered the relevant investment according to a cover test set out in each trust deed. On this basis, the developers agreed to buy the Peninsula Village site in April 2007 and acquired shares in a local company which owned the Marrakesh site in November 2007. The solicitors then subsequently released to the developers tranches of the investment funds for each development. In May 2008, the Financial Services Authority prohibited the developers from receiving any further investment in relation to either development, and the developers were unable to complete the purchase of either site. The developers were wound up in November 2009. The investors have brought 2 actions against the developers' solicitors, one for each development site. The investors allege that the solicitors released their funds to the developers in breach of the cover test, depriving the investors of adequate security. The investors' claims total over £10 million, taking both development sites together. The solicitors have professional indemnity insurance with the appellant insurers, limited to £3 million in respect of each claim. The insurers contend that all the investors' claims for both sites constitute one claim, or alternatively no more than 2 claims under the aggregation provision in the solicitor's insurance. Mr. Justice Deere rejected that contention. While all the claims arose from similar acts and omissions, they did not, in his view, arise in a series of related matters or transactions, since the transactions between the developers and each investor were not mutually interdependent. The Court of Appeal adopted a different test, holding that to satisfy the aggregation clause, the matters or transactions would have to have an intrinsic relationship with each other, not an extrinsic relationship with a third factor. The Supreme Court unanimously allows the insurer's appeal. Lord Toulson, with whom the other justices agree, gives the lead judgment. The relevant clause in the solicitor's insurance based on the minimum terms and conditions of the Law Society, has 2 limbs, each of which must be satisfied for aggregation to apply. The claims must and did arise from similar acts or omissions. They must also be in a series of related matters or transactions. That is an important limitation without which the scope for aggregation would be almost unlimited. However, the Court of Appeal's test of an intrinsic relationship is unnecessary and unsatisfactory. The word related in the clause implies that there must be some interconnection between the matters or transactions, but nothing suggests it must be intrinsic. Whether transactions are sufficiently related is an acutely fact-sensitive exercise. The aggregation clause is not to be applied from the perspective of any particular party, but objectively taking the transactions in the round. Here, there were 2 sets of related transactions, with investors, each involving an investment in a particular development scheme under a contractual arrangement that was primarily bilateral, but had an important trilateral component by reason of the solicitor's role as trustees and escrow agent. The transactions entered into in respect of each development were connected in significant ways. Each set of investors invested in a common development and became participants in a standard scheme and co-beneficiaries under a common trust to complete a particular development. On the facts as they currently appear, the claims of each group of investors therefore arise from acts or omissions in a series of related transactions. The transactions shared a common underlying objective of the execution of a particular development project and also fitted together legally through the trusts. However, the transactions entered into by the Peninsula Village investors cannot be said to be related to those entered into by the Marrakesh investors. They related to different sites, had different groups of investors, and were protected by different deeds of trust over different assets. They should not therefore be aggregated together. The result is that there were and are two claims, each subject to the £3 million limit.